There we go.
So it's picture coming, no comment.
Okay, this is DC 20-12681, Stephen Kaplan PC versus James Roberson. The proceeding is a formal proceeding of the 95th District Court, and it is being conducted fully in compliance with the statutes and the Constitution of the state of Texas, including the open courts provision of the Texas Constitution. Because we are operating remotely today, and the courtroom is therefore locked, and we need to create public access to this proceeding, we are broadcasting this proceeding on the court's YouTube channel in order to allow for public access to this proceeding. For the record, if you have an interest, the Office of Court Administration maintains a constantly refreshing list of all courts that are broadcasting on YouTube live at any given moment, and therefore the public would have access to this proceeding by going to the Office of Court Administration or by going to the 95th District Court's YouTube channel and clicking on the watching it live button. Because this is being conducted over remote means, there is a possibility that one or more parties or the public might record this proceeding either directly by recording off the screen or by saving the video file. I'm here to advise that that is not permitted. Recording of proceedings in the district courts of the state of Texas cannot be made unless there is a court order expressly authorizing such recording in a specific proceeding. I've neither been asked to, nor have I issued an order authorizing recording of this proceeding. Therefore, the only record that will be maintained of this proceeding is the record maintained by the official court reporter of the 95th District Court, Ms. Rouse, who is here and who will report this proceeding. Having said all of those things, let me take the introductions of counsel, starting with Mr. Kaplan.
Your Honor, plaintiff Stephen Kaplan PC is here, represented by myself, Stephen Kaplan.
Very good. Mr. Roberson.
My name is Mr. Roberson. Trying to represent myself. I haven't had a chance to get an attorney. Don't have the funds, and I'm trying to get some time to try to get that done, because I really don't know what I'm doing.
Well, Mr. Roberson, the court notes, and welcome to the 95th District Court. The court notes that you had counsel, and you and he parted ways by way of a hearing that we had. Oh, I'm guessing it was 10 days ago, roughly. And it was my understanding you wanted Mr. Manister to be authorized to withdraw. Did I misinterpret that?
Yes, sir. I think it was, my point was this. Mr. Manister sent me an email for more money, and I didn't have it, and he told me he was going to withdraw from the case unless I give him $1,500 more. And that's what he did. He sent me an email to withdraw from the case, and he said he sent it to Mr. Kaplan, and he asked Mr. Kaplan to give me more time to try to find an attorney. And I have the records that I paid him, and I have it with me now. And so I didn't have no way of showing you the evidence. But that's why he wanted to withdraw from the case, because he said in the writing that he sent me the email that I never paid him. And I did. I wired the money to him.
All right, that is between you and Mr. Manister. I made it very clear in the hearing in which Mr. Manister was seeking authorization to withdraw as counsel that I was not going to use that withdrawal as a means to delay this proceeding. I understand you want counsel, but I'm also cognizant of the fact that we're here about a payment or a lack of payment to previous counsel, and then Mr. Manister withdrew because of payment to counsel. And therefore, the court is inclined to proceed with the motion for summary judgment. I think the court was pretty clear at the last hearing that the withdrawal of Mr. Manister could not be used as a basis for a continuance of today's proceeding. What do you believe counsel would be able to do for you in the defense of this litigation by Stephen Kaplan, PC?
Okay, Your Honor, I believe if I had more time, I did talk to another attorney, and he's wanting money right now. He said he would be willing to help me, but I don't have the funds. I'm not working. Mr. Kaplan knows I'm not working. And that's why I asked for time to try to get somebody to help me, because I don't know nothing about how to do this court. I had trouble trying to get on this Zoom. I couldn't do it. I had to go to a friend to help me with it. And I apologize for that. That's not your problem. I just need some time. If I can, 10 days wasn't enough time for me to find an attorney to try to continue with the case.
Let me try. That really didn't answer my question. Let me try this another way. You have been sued by your prior lawyer, Stephen Kaplan, PC. He is alleging that you owe him money for the defense of another lawsuit. If you were to hire a lawyer to defend this lawsuit, what do you think the lawyer would be able to do to defend the claim for attorney's fees from the previous lawsuit?
Could I explain that to the best of my knowledge?
Give it a try.
Okay, Mr. Kaplan told me the customer got 2 houses. When I won the case, March the 13th of this year, he said he filed a lien on the property. He said, and by the time that's settled, we would get our money. So I never knew in August, that I was going to be sued by Mr. Kaplan. He said he would work with me. Once the trial was over and the appeal was done, we would go and get the house, and we would have our money from that. So that's what I was expected. So in some kind of way, I feel like I'm being misled from Mr. Kaplan. We sat down and talked about all of this, and what he told me, he said, you'll get the house. She got a rental house. It'd be hard to get the homestead. So that's what I expected. And then I get a letter sent to me that I'm being sued by Mr. Kaplan. I don't have $100,000. I'm broke. I'm behind on everything. And when I paid him right at $10,000, I gave him all the money I had. Mr. Kaplan worked very hard to help me with this case, and I won the case. I didn't know I was going to get sued, and I haven't had anything else justified so far.
Mr. Kaplan, how do you respond to that?
Well, number one, Judge, I've tried this. The original lawsuit involving Ms. Laws was tried twice. Once in the JP court, she appealed. We forced her to furnish a partial appeal bond, because that's when we finally learned that there were 2 houses. One, the house that she was living in, but another house that she called the family homestead, and she never listed it on her application for assistance, and we finally got the judge to order a partial bond for about $4,500. My fee agreement with Mr. Roberson made it clear from day one, and I told him that I will not represent him on appeal. I am not an appellate attorney. In fact, the Exhibit A says no ancillary litigation and no appeal. And that's part of my fee agreement with him. We tried it twice. I tried to work with Mr. Roberson because I thought Ms. Laws was being abusive, and we ended up going to trial and trying it. Obviously, as Mr. Roberson said, we finished the trial. March 13, got a verdict in our favor, and then there were post-verdict motions. Ms. Laws did get an attorney, and that caused more problems. The judge signed an order that was wrong, a judgment that was wrong to begin with, so we had to have a nunc-pro-tunc on that. And at the end of the day, the attorney's fees were obviously significant. The judgment was in excess of $62,000 on a dispute that was originally for $5,000. It's unbelievable how much effort was taken in this matter. I told Mr. Roberson I can't continue to represent him. I tried to help him with the Dallas Bar Association appeal section and the State Bar appeal section to find an attorney who might be able to represent him on a either pro bono basis or a lower cost basis. Of course, COVID hit, and that created some problems for Mr. Roberson to find someone who could represent him on a pro bono basis. But in any event, I told him I could not do that because Ms. Laws filed her appeal to the Fifth Supreme Judicial District before the judgment was signed. Technically, I was his appellate attorney, so I had to, not only did I withdraw from the trial court, but I had to withdraw from the appeal court as well. And Mr. Manister was supposed to represent him on the appeal and never did. That's between Mr. Roberson and Mr. Manister, not me. But I had dealings with Mr. Manister, assuming he was going to represent Mr. Roberson on appeal, and he never did. In any event, I don't think there are any defenses to the motion for summary judgment. No response has ever been filed. There are business record affidavits and my affidavit of attorney's fees, an affidavit of what the post-judgment interest would be and pre-judgment interest would be. I don't think there are any defenses at all, and clearly Mr. Roberson hasn't paid me for the work that I did, which he acknowledges was substantial, 2 trials, and all this post-verdict activity as well. And I believe that the plaintiff is entitled to summary judgment on all of the claims it has raised. And there's never been a sworn answer to the pleading as required, because there's also an affidavit of account, no verification under 185, Rule 185, that there are any defenses.
What's the status of the appeal? Does anybody know?
They sent me an email that I was supposed to go to court in January the 19th, I believe. They did grant me more time to get an attorney, and I'm not working, but I have spoken to an attorney that says, you know, he'll give me some time to try to get some funds together, and he'll let me make payments to try to get this resolved some kind of way. I've never been through this before, never went to no jury, none of this. I will say, I thought Mr. Kaplan worked very hard for me, but the excess expense, I didn't understand. And I sent him an email trying to explain myself, and then I didn't know I was going to get sued. You know, I thought that once the trial was over and the appeals was over, that we get the property, the rental property, because he said it's too hard to get the homestead. He said, but the rental property we'll get, and then we could get paid then. So that's what I expected. I didn't expect to be in court for being sued, uh, don't have any money. And he know this lady went to the Better Business Bureau on me. I think that affected my work. I may get a call maybe in a month. Once a month, I may get one call for work, and there's just been small jobs. So with a family, and just hadn't been able to to proceed. I don't believe that no one should work for free, but it was just explained to me that you know my thought when we won the case and we won the appeal when it's due, that we could go after the house, garnish her wages, all of this, and then I could see how we could come together with me and Mr. Captain on trying to get him some money. That's what I clearly thought. Your Honor, I'm just in bad shape. People not letting you work because of the COVID. So you're just fortunate if you get any job right now. And I'm behind on all my bills, not just one of them, all of them. And
Mr. Kaplan, did the judgment from County Court at Law number 4, I'm not looking at it, I guess I can pull it up. Does the judgment from County Court at Law number 4 include conditional fees on appeal?
No, it doesn't, Your Honor, and the reason why it doesn't is because Ms. Laws, as part of her summation to the jury, said, if you find against me, I'm going to file for bankruptcy tomorrow. But it does not, Your Honor.
All right. Why? So Judge Rosales decided not to include appellate fees?
Judge Rosales did several things. Number one, we couldn't even recover all my attorney's fees because Judge Rosales said when an appeal of a JP judgment is filed in her court, you're not entitled to do any discovery and you're not entitled to attorney's fees for discovery. So my attorney's fees were greater than the amount the jury awarded, but the judge said you can't put on evidence about that. Obviously, I objected to it, and that's part of the appellate record. Of course, there is no attorney representing Mr. Roberson on the appeal, and Mr. Roberson doesn't know how to do that, and I understand that completely. That's why Mr. Manister or another attorney was supposed to be hired to represent him to potentially file a cross appeal saying the judge made terrible mistakes in terms of what she allowed in evidence or didn't allow as evidence. But that's not something I'm competent to do. And eventually Ms. Laws did get an attorney to represent her post-verdict and to file an appeal. I tried to get Mr. Manister to take care of it, but apparently he decided he was going to file an answer in this case instead. I have no answers about that at all as to why that happened. Obviously, I've tried this case twice. I tried to work with Mr. Roberson. When we got into the county court, he wasn't paying me. I think he made one payment and that was it. And Ms. Laws is just incredible in terms of how much work she required us to do. I think the transcript, it was a 3-day trial, 3.5-day trial in county court at law on a $5,000 claim. The judge let her bring in all these other people that Mr. Roberson dealt with. I don't know why that was relevant, but that's what the judge's decision was. But in any event, we did the work. Mr. Roberson said the work that we did was good. The other house that Ms. Laws has an interest in, was willed to her, but she never probated the will. Instead, she wrote to the DCAD saying, this is estate property. And so it's sitting there. She's got a will that she hasn't probated that leaves the house to her. Obviously, Mr. Roberson is not going to probate that will. But in the meantime, she's got the taxes in abeyance because she filed a copy of the will with the DCAD saying this is estate property. So we addressed that matter to the judge when we finally got the judge to post bond.
Okay.
In the trial, by the way, in the trial court, she did have two different attorneys at some point in time, one of whom didn't had an expired license. It's that kind of case. With regard to the motion for the continuance, Your Honor, the court has previously told Mr. Roberson continuance is not going to be considered, and it was.
Well, I'm aware of what the court. I'm aware of what the court previously told Mr. Roberson. I'm also actually looking at this moment at the appellant's brief in the Fifth Court of Appeals. These same attorney's fees that are the subject of this suit are the attorney's fees that are on appeal in the Fifth Court of Appeals, correct?
The entire judgment is on appeal. Yes, Your Honor.
And we're talking about $62,500 that were found by the trial court?
Found by the jury, yes, Your Honor.
Oh, found, all right. Well, all right.
There were more, and I tried to put on evidence that there were more. But
I understand. I do understand. I also understand the recent Supreme Court opinions on attorneys' fees and the whole concept of fee shifting, and which isn't inherently an issue here.
I mean, the problem I have, Your Honor, is I'm not the appellate attorney. I never told Mr. Roberson I would represent him on an appeal. My fee agreement says that we would not represent him on appeal. He hired Mr. Manister and tried to hire other attorneys to handle the appeal. I have no control over what he did. I tried to help him any way I could.
Mr. Kaplan, I'm aware of that. I'm also aware that Mr. Roberson I don't want Mr. Roberson to be a victim of the system. And I'm trying to not do that. All right, Mr. Roberson.
Yes, sir.
I see that you have a deadline, and I'm looking at an order from the Court of Appeals that you have a deadline, not for court, but you have a deadline to file your brief responding to Ms. Law's brief in the Court of Appeals, and that deadline is January 19, 2021. Mr.
Yes, sir.
Kaplan, I know this is not going to make you happy, but this court is not going to hear the motion for summary judgment until Mr. Roberson's had an opportunity to file his brief in the Court of Appeals.
Your Honor, it certainly doesn't make me happy, and I understand Mr. Roberson said he can't afford an attorney. in this case, I don't think he's going to get one in the appellate case.
Well, and that may well be the case, but it's also, all it's doing is slowing down the judgment. It's not slowing down your collections. It doesn't sound like any. And
That's certainly the
so
case, Your Honor.
I'm not going to complicate Mr. Roberson's ability to defend the judgment on attorney's fees in the Court of Appeals, since we're talking about the same body of fees. So I'm going to continue the motion for summary judgment hearing until after January 19, 2021.
Do we need to set a date for that?
I'm not going to set that date today, but it will be until a date after January 19, 2021. And I will let you get a hearing on that. It will also be in front of Judge Purdy, not me.
Thank you, Your
Judge
Honor.
Purdy takes the bench of the 95th on January 1.
Thank you, Your Honor.
Mr. Roberson, you're welcome, but that's, the court is not here to be thanked per se.
Okay.
I will point this out. You have a deadline to file a brief in the Court of Appeals, and that deadline is January 19, 2021. And looking at Judge Malberg's opinion, it does not appear that he as the appellate panel that agreed to extend your motion will be inclined to extend that deadline. So I suggest you focus your attention between now and January 19 on getting a lawyer to file a brief in response to that brief that Ms. Law has filed, which, skimming it while we've been here, appears to be all about this same body of attorney's fees. You understand that?
Yes, sir.
Okay. Is there anything further?
No, Your Honor.
No, sir.
Mr. Kaplan, I'm going to say one other thing. I'm also aware of some history involving another counsel on this case, and that is somewhat, and not on your end, but that is entering into my consideration also. This is not the first lawsuit that one of the attorneys who was previously in this case has been involved in. And Mr. Roberson would not have known that either, but I am aware of it, and I'm just not going to make him anymore. I'm not going to allow him right that. I'm not going to make him a victim of the system. I'm going to give him every chance to address this.
I understand, Your Honor.
All right.
May we be excused?
You may be excused.
Thank you.
Thank you.
And Ms. Rouse, we